सर हम ज्वाइन कर रहे हैं ना, वेबिनार स्टार्ट हो रहा है 2 बजे से है ना सर? 2 बजे ना जी जी। ये आ रहे थे चेयरमैन सर? वो नहीं आ रहे वाइस चेयरमैन तो बैंक
Good afternoon, sir.
सर प्रणाम सर।
हाँ नमस्ते।
Hello, sir.
अभी करते से वेलकम करना बोल दो ना।
On behalf of Modern Group of Institution, I welcome all the participants, all the attendees, and all the panel members. Welcome to the national webinar on clarification to India Article 30 issue unsolved. Good afternoon, sir.
Very good afternoon.
सर प्रणाम सर।
नमस्कार पुनीत जी, कैसे हैं?
एकदम बढ़िया हूँ।
नमस्कार।
थैंक यू सर, नमस्कार।
Sir, with your due permission, shall I start, sir?
मैडम चेयरमैन सर ज्वाइन हो चुके हैं। चेयरमैन सर ज्वाइन हो चुके हैं।
हाँ सर।
हाँ सर से वेलकम कराइएगा।
A very good afternoon to everyone. Today we all are gathered here for the national webinar on clarification to Indian Article 30 issues unsolved. Am I audible to all of you, sir? The panel member, am I audible? So a very warm welcome to one and all present here, all the attendees, all the panel members, our respected chairman, sir, respected group director, sir, and of course our guest and speaker of the today, Shri Pushyamitra ji. I, Arpita Patel, Head Media and Corporate Communication, on behalf of Modern Group of Institution, welcome you on the national webinar series #Modern Talks. So before starting the program, I would like to give a brief introduction about our organization. It will take a moment, sir, because I have to make the page live as well. Just a minute. Yeah, I'm so sorry to keep you waiting. So once again, a very warm welcome to Modern Group of Institution and a webinar on national webinar on clarification to Indian Article 30 issues unsolved. So before moving further, I would like to give a brief introduction about our organization. Modern Group of Institution is a leading group of premier institute in Indore, affiliated to RGPV Bhopal, Devya Hilya Vishwavidyalaya Indore, CBSE New Delhi, and approved by AICTE New Delhi, NCTE, and PCI New Delhi. Modern Group is imparting quality education in the field of pharmacy, management, commerce, and education, and we offer more than 8 courses in these fields. That is B Pharma, M Pharma, D Pharma, BBA, BCom, MBA, BCom, and B.Ed. Modern Group encompasses 2 leading pharmaceutical industries, Modern Lab and Nandini Medical Private Limited Laboratories. Modern Lab was established in 1979 by late Shri P.C. Khariaji, and Nandini Medical Laboratories was established in 1998. Both gained prestigious accumulation in the area of All India rating of pharma industry. We also have Modern International School established in 2013. We believe in innovation and entrepreneurship. Hence, we have Modern Incubation Center, MP's first pharma incubation center. Recently, we have received a World Book of Record UK and World Record Academy USA for making largest human image of medication capsule. Also, we are recognizing participating institute of Unnat Bharat Abhiyan associated with IIT Delhi and MHRD Government of India. The institute has also been Modern Innovation Council, which is an institution innovation council by MHRD Innovation Cell. This is about our organization. Now, I would like our respected chairman, sir, Mr. Anil Khariaji, to welcome our guest.
सर अनम्यूट करिए, अनम्यूट करिए।
Sir, your voice is not audible. Yeah. Now
Good afternoon, sir. मॉडर्न ग्रुप ऑफ इंस्टीट्यूट्स ने एक वेबिनार सीरीज जो आपने स्टार्ट की है मॉडर्न टॉक्स में, जिसमें हम काफी सारे टॉपिक्स अलग अलग समय पर लेते रहे हैं, जो पब्लिक इंटरेस्ट के भी हैं, एजुकेशन के इंटरेस्ट के भी हैं, एंटरप्रेन्योर्स के इंटरेस्ट के भी हैं। और इसी तारतम्य में आज जो हमारा एक टॉपिक था कि जो आर्टिकल 30 के ऊपर बहुत सारी चीजें लोगों को उतना आइडिया नहीं है, तो यू आर द, आई थिंक यू आर द बेस्ट पर्सन कि हम आप इसके ऊपर प्रकाश डाल सकते हैं। वी वेलकम यू सर, और वी वेलकम ऑल द पार्टिसिपेंट्स ऑफ दिस वेबिनार, and so we will be listening and it will be a great session today.
Thank you so much, sir. Thank you so much for your kind words. I just want to update all the panelists that we have approx 96 participants with us right now, and it is increasing. Now, before moving further, I would like to give a brief introduction about our guest, Mr. Pushyamitra ji. So I'll just share the slide before that. Advocate Pushyamitra ji Bhargav is Additional Advocate General at High Court of Madhya Pradesh bench at Indore. Mr. Bhargava completed his MPhil from School of Law, Devi Ahilya Vishwavidyalaya, Indore. He has done BA LLB Honours and LLM in Business Law from School of Law, Devi Ahilya University, Indore. He has done Diploma in Cyber Law from Asian School of Cyber Law at Government Law College, Mumbai in April 2005, and Certificate Course in Journalism and Mass Communication from Allahabad University. Mr. Pushyamitra Bhargava presently practicing at High Court of Madhya Pradesh bench at Indore. He has also worked as Deputy Advocate General, High Court of Madhya Pradesh. He is also advocate on panel for Aditya Birla Retail Marketing Limited, Indore, and advocate on panel for State of Madhya Pradesh at High Court of bench at Indore. Mr. Bhargava conducted cases and appeared on behalf of Indore Development Authority, various municipalities and corporate clients, educational matters related to services and jurisprudence, arbitration matters, criminal, civil, miscellaneous cases. Mr. Bhargava is president of social welfare organization Sanstha Sanghamitra and Jagrata Yuva Sansthan. He is group leader of various legal literacy camp organized in village of Madhya Pradesh and Northeast. Members of political youth delegation to China organized by Ministry of Sports and Youth Affairs, Union of India. Mr. Bhargava fought for public interest by way of numerous public interest litigations and also for the welfare of students at large and associated with various social organizations working in the field of youth and community development. On behalf of Modern Group of Institution, I feel honored to welcome you, sir, on the national webinar series, #Modern Talks. Now, I would like you to start an introductory talk on the topic.
Thank you very much. It's really a matter of great pleasure for me to be the part of this webinar series that you have called Modern Talks. Certainly all the topics which you have discussed earlier are of great importance for making a modern India, rather making India the Vishwaguru. The chairman has just welcomed me and he has said that I would be the best to be speaking on the today's topic. So I'll try my best, because as a lawyer and as a law student, it's always a learning process, and I'll try to justify the selection of your group on the topic. Certainly this Article 30 is the hottest topic of debate at present in India. There are various provisions which have been included in the Indian Constitution. The framers of the Constitution set for more than almost 2 years to come up with this beautiful bunch of flower. The Part 3 of the Constitution of India, as we all know, provides for the fundamental rights. Similarly, though we opted this secularism at the later stage, the Part 4 of the Constitution of India, which is the fundamental rights, But this Article 30 was inducted to protect the rights of linguistic and religious minorities in India. To understand this, we need to understand the background. At the time of the preparation of the constitution, rather before that in 1931, a draft was prepared to protect the religious minorities and the linguistic minorities. So the provision which we see in the constitution was not proposed by the Dr. K.M. Munshi. What was proposed was that explicit and equal educational rights to all communities. But when it went to the minorities subcommittee for the preparation of the constitution, that minorities subcommittee reconsidered it, and what has come out is there in our constitution as Article 30. So I'll just read out one again, what Article 30 says. All minorities, whether of religion, community, or language, shall be free in any unit to establish and administer. So these two words, establish and administer, is of great importance. And the third is establish and administer educational institutions of their choice. So the paramount importance is given to the administration of educational institutions of their choice, and they shall be entitled to state aid in the same manner and measure as is given to similar state aided institutions. So the minorities of the linguistic or religious nature will be given the same aid as given to the other aided institution, number one. Number two, they can establish the institutions of their choice for educational purpose, and they will be having full liberty with regard to the establishment and the administration. For example, the management of the college will be decided by the society running the minority institution. With regard to the admission process, the criteria will be decided by the institution. So this is with the purpose to protect the minorities, whether linguistic or religious. But the question is of paramount importance to start this discussion is, what is minority? Who all will be included in the minority, whether linguistic or religious? So the Constitution of India nowhere defines who is the minority, or there is no such legislation which provides that who will be treated as the minority. For example, in 1950, Muslims, Christians, and Parsis were the minorities at the initial stage. Later on, as on today, Sikh, Buddhist, and Jains are also included in the minorities. So the Muslims, who are considered to be the minority because their population is less than Hindus. So can that formula be applied in state of Jammu and Kashmir, where the Hindus are in minority? So it's a very dark area which requires a consideration, because in the valley of Kashmir, the rights of Hindus who are minority as by the way of population is to be protected. So in the state of Jammu Kashmir, this article does not apply in the same sense which it applies in the rest of the India. For example, the Christians in Meghalaya and Nagaland, their population in Meghalaya and Nagaland is more than 90%. Even there, they are treated to be minority because as compared to the population of the rest of the India, they are minority. So to protect their religious minority, they can enjoy the right protected under Article 30. So this is the explanation which has been taken to define the minority on the basis of their population is required to be reconsidered. There is a dire need at present to define minority so that the constitutional provisions and the protections which are given can be given equally to all the religions, all the sanctums. Similarly, now you talk about the linguistic minority. So after the independence, the creation of the state is based upon the language, like Pashchim Bengal, Bangla, Maharashtra, Marathi, Gujarat, Gujarati. So you assume a situation that a Gujarati society, a bunch of Gujarati peoples running an educational institution in Maharashtra. So that Gujarati linguistic society will be a minority in Maharashtra. Though the Maharashtra peoples are will not be enjoying that linguistic minority. So in case if they are running that society in other state, then only they can enjoy that right. Though the Maharashtrian people are working for the protection of their rights. So this is the situation which needs to be considered while considering and discussing this Article 30, because there is an absurdity or there is a vacuum in deciding what exactly the linguistic or religious minority will mean. Now, from the insertion of this Article 30, by discussing this Article 30, we need to actually discuss two other constitutional provisions which are directly relevant to this Article 30. I'll just read out from the Constitution of India what the Article 26 and Article 28 says, because without discussing these two articles, our discussion is of no use. Now the Article 26 says, freedom to manage religious affairs, subject to public order, morality and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purpose, to manage its own affairs in matter of religion, to own and acquire movable and immovable property, to administer such property in accordance with law. Now moving ahead, section 28, the Article 28, freedom as to attendance at religious instruction and religious worship in certain educational institutions. More or less, the complete Article 30 talks about the educational institutions. So this Article 28, subclause 3, no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to take part in any religious instructions that may be imparted in such institution, or to attend any religious worship that may be conducted in such institution, or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given this consent thereto. So what I am pointing out is that on one hand, this Article 28 restricts all those educational institutes, those are state aided, to profess or to teach or to conduct the religious activities. And on the same hand, the Article 30 subclause 2, which we are discussing, empowers the minority institutes to take state aid as given to the other institutes, and they are also free to administer and run their institutes as per their own wish. They may take on the teachings of the religious purposes. So this Article 28, when read along with the Article 30, somehow creates an impression, or rather, in my considered opinion, in my personal view, violates the Article 14 of right to equality, equal opportunity be given to the all educational institutes, whether run by the minorities or by the non-minorities or by the majority establishments. So this is the question which is actually to be considered by the Honorable Supreme Court, because this Article 30 has been interpreted time and again by the Honorable Supreme Court. Initially, it was started by one of the judgment when a reference was sent to the Honorable Supreme Court in the case of Kerala Education Bill judgment. So it was observed by the Honorable Supreme Court that this article leaves it to the choice to establish such educational institutions as will serve both purposes, namely the purpose of conserving the religion, language or culture, and also the purpose of giving a thorough, good general education to their children. So this interpretation empowers the minority institutes for the administration to save or to promote the religious and cultural education, and also to receive the state aid as given to the other institutes. But the other institutes which are receiving the state aid cannot profess or teach the religious activity by the clause as provided under Article 28, subclause 3. So this 28 subclause 3 is required to be reconsidered. Similarly, in this St. Xavier's College judgment pronounced by the Honorable Supreme Court before the TMA Pi Foundation judgment, which is the basic judgment or the judgment which has clarified the Article 30 in all its senses without considering the aspect of majority part. So in this St. Xavier College judgment's case, why I am pointing out this judgment is because the Honorable Supreme Court has only interpreted this Article 30. Every administration of the institution is based upon this interpretation which is given by the Honorable Supreme Court. Because at many times these states like state of Kerala, state of Madhya Pradesh, state of Gujarat has tried to make some restriction on this type of institution. They approached the Supreme Court and this article was then interpreted, which I am reading out for you. In the St. Xavier College case, with regard to the affiliation to a university, this is very relevant for all the educational institutions. With regard to the affiliation to a university, the minority and non-minority institutions must agree in the pattern and standard of education. Regulatory measures of affiliation enable the minority institutes to share the same course of instructions and the same degrees with the non-minority institution. So this was the judgment which led or which gave the powers to the affiliating authorities to just keep a check on the non-minority institutions also, that you are also required to follow the standards of education and exams which are being kept for the majority institutions or the institutions which are run by the majority associations. After this came the judgment of Honorable Supreme Court in the case of TMA Pi Foundation. In 2002, the Supreme Court very deeply discussed this Article 30 and has observed that following points to be considered while protecting the rights of the minority institutions. Number one, all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. This is the language of Article 30. So the majority institutes are free to open the educational institutions, and even they have right to earn profit out of it, because that right flows from the Article 19 to profess any business. And what has been finally decided, that all the minority institutes will have an exclusive right to admit students, number one. Number two, to set up their own reasonable fee structure. The word which is used is reasonable fee structure. They can constitute their own governing body. They can appoint their own staff. They can take action if there is any dereliction in duty on part of any employee. So this can be done by the administration or by the management of the minority institution, not by the state government. So by giving the protection of Article 30, this has been empowered to the management. Now I'll just point out a table that what a majority institution, meaning thereby an institution run by the majority religious or linguistic group as compared to the minority group. Like recently, the government of India has enacted Right to Education Act. Now that provides for 25% of reservation for the students, those who are in need of upliftment, especially below poverty line, economically weak. So that act provides for the reservation by all educational institutes. But this will not be applicable to the minority institutes, because in the light of this Article 30, they are protected by the Honorable Supreme Court that you have right to admit these students, which has been pronounced in the TMA Pai Foundation judgment. Similarly, screening of the students cannot be done by the institutes run by the non-minority establishments, but the screening of the students can be done by the minority students for the sake, though there is a judgment in the St. Xavier's case that they have to admit the students from the class or the linguistic or religious minority of the society other than that society which is running that college. So the general students from the majority class can also be admitted to the minority students, but their number is fixed. There can be a screening of that admission. Now with regard to fee and other thing, the minority institutes cannot be regulated, but the other colleges and schools can be regulated by the state government. Appointment of teacher, the regulation can be done by the state government over the institutes run by the majority association. Similarly, selection of principal, which is the foremost important criteria. So minority institutes, the management can select their own principal and can govern their rules. Religious teaching in the institutes, the minority institutes, they are permitted for the religious teaching, but as far as the other institutes are concerned, that bar flows from Article 28. So looking to all these judgments and the reading of the Article 30, the extraordinary rights have been given to this minority institutes, and there is no check. So in my view, this Article 30 requires reconsideration by the central government, that whether any amendment can be brought for keeping a check, because just by making a society having members of minorities and administering an institute by not following the other provisions which are required to be done. This requires an amendment in my opinion. Even this requires a reconsideration by the Honorable Supreme Court, that how a check can be kept on these institutes just for the sake of two reasons. That on one hand, they are permitted for their religious teaching. The other groups like majority Hindu institutes run under the provisions of different act and rules framed by the different states, but they cannot profess their religious teaching. So one or the other way, this is somehow discriminating the majority with minority. Secondly, the capitation fees and the screening procedure. The minority institutes can charge certain fees, can screen the admission. Like for example, if somebody wants to study in the Aligarh Muslim University, so there will be a screening because they claim it to be a minority institute. Though it's a central university, that debate is still on. So that requires a consideration. This biggest impact is on this Right to Education Act, which has been recently framed for the welfare of the children. So what has been provided under right to education is not implemented by these minority institutions. Certainly, the linguistic and the religious minorities must be protected to safeguard their culture, to safeguard their language. But that does not mean that they be given extraordinary powers to discriminate with the other parts of the society. The intention of the framers of the constitution was to safeguard their cultural rights and religious rights. So with the passing of this 70 to 75 years, now the time has come for the reconsideration of this provision, especially when the population has been made as the criteria to decide the minority and majority. So just to sum up from my side, either the Honorable Supreme Court in its suo motu reference, or if some cases reaches there, has to reinterpret the provisions of Article 30, or there is a dire need for the amendment of this Article 30 read with Article 28, subclause 2 and subclause 3. Hope I was able to project what actually started with Article 30 and where we have reached.
Yeah, sir, that was very, informative, and I think almost all the participant has get a clear idea what is Article 30 is all about and what amendment is needed for the Article 30. Now we have a lot of question in our question answer box, sir, and we have almost 101 participants with us right now. And before, I have also chalked down some question, but I think 2 or 3 questions you have already answered. So I will ask the first question from the participant itself. That is Rashmi Vaida, that how can the government merge madrasa education with modern education system? What is the future of Indian madrasa education? So can you please shed some light on this, sir?
So as far as the madrasa education is concerned, the central government as well as all the state governments have given them right to run their madrasa, profess their education. But in my opinion, the education which is taught by the states and the central government also through CBSE, that should also be taught in the same way as the religious education is going on. So by the judgment in the case of St. Xavier's case, they are bound to follow the courses, syllabus and the affiliation which is given under the school education by the Central Board of Secondary Education or by the State Board. So both the things can run together, and that is rather good for the upliftment of the students from that class who are only taking classes from the madrasa.
I hope the answer is clear to the participant Rashmi Baida. Now, my next question is from my side. What are your views on the ongoing internet warfare on striking of Article 30?
In social media, there are two items are floating. One, that the Hindus are not allowed to profess their own education system and the religious values. So that in way of they are saying that there is one Article 30A which restricts the Hindus. So there is no such Article 30A. So that news itself is very fake. First of all, I want to clear it. Second, which you have asked is internet warfare for striking of Article 30. I think at present there is a need of reconsideration. So what is going on internet is to be considered not for the sake of striking off, but just for the sake of protecting the rights of majority students, with vis-a-vis protecting the cultural and religious rights of the minorities also. They also are required to be protected. For example, the linguistic minorities of Northeast. So until and unless there are educational institutes professing that education, having the linguistic importance of their tribes or their local languages, so striking Article 30 would not serve the purpose. The purpose can be served by amending it and providing rights to the other majority groups also, those who are willing to profess their religion, their languages, and their old culture.
So, sir, can we say that Article 30 is delivering benefit to the minority institution, which are actually not minority in the same state, in some states?
Okay, can you come again?
Yeah, is the Article 30 delivering benefits to minority institutions, which are actually not in minority in some states? Can we say that?
See, those institutes which are minority are not minority.
Yes, exactly,
In
not
some
minority
states.
in some states.
The purpose of Article 30 is to protect the religious and culture linguistic minorities. So in case by administering an educational institutes, even they are not minority in that institutes and they are able to protect it. So that is also one or the other way helping that minorities. So in my total consideration, by any means, if we are fairly in position to protect the culture and language by any means, then the purpose of Article 30 is served. But what we have seen is the complete somersault. What we have seen is the complete misuse of this provision. What we have seen is the misuse of the state funds which have been given to them. So that requires a check.
So the same question has been, some of the input in this question has been asked by Vishweshwari Matholia, that what guidelines should be opted to protect the misuse of this article? What amendment should be done to protect this article? What is your opinion?
There has to be, because now anything can be done by reconsidering this judgment of TMA Pi Foundation. So what is required is that the state should be given, state or the central government should be given some liberty to check the administration and the management of this minority institution. The state or the central government representations should be made in such societies so that they can keep a check on it.
A check is required, that means. My next question is just in the row itself. that does the same reason still exist when Article 30 was incorporated in the Constitution of India as in today's context?
As I've initially said, that what was proposed was something different and what has come out is different. So
Yeah.
with the larger perspective and reading the article as it is, there still exists a need. As I have given an example of the northeastern states, to protect their language and culture, need is there, but what is required is a check.
So I just wanted to know that, is there any parameter when does a minority should become majority? Is there any parameter in that article?
As I have initially in the starting of my as I am audible?
Yes, sir.
So initially I have said that as the constitution nowhere defines what is minority. So first of all, there is a need of a legislation or some definition about the minority. So until and unless we come to the conclusion with regard to who is minority and who is majority, this cannot be done. For example, in Jammu and Kashmir, the Hindus are in minority, but as compared to overall population, the Muslims are treated to be minority there.
Thank you so much, sir. That was really very informative. My next question is, Article 30 talks about minority education institution and they receive some financial support by the government. Is there any limit for that?
As per Article 30 subclause 2, it is clear that the all minority institutes will be given the same aid as given to the other institutes. So whatever is the budget which is prepared by the state government or by the central government to add the educational institutes run by the other societies or by the government, same aid will be given to them. So that is virtually based upon the yearly budgets and the need of the time.
Okay. Thank you so much, sir. My next question is, how much is the judiciary affected by the protest, demands, and social media trending warfares?
Every judge is a human being. And a human being is always affected by emotions, human angles. Initially, when this social media came, there was a much disturbance. I personally think everybody was somehow affected by it. Even we have heard the news about the media trials. What media was publishing was going inside the courts. But now again, the trend has changed. The honorable judges and the judges of the trial court are certainly not much affected by this media representation, media publication, or by the social media.
Okay. So now they are not affected by that, by whatever.
And they should not, and they should not, and they should not. They should always decide based upon the facts placed before them.
That is very true.
They should decide the
and
case
only they
based
can give an unbiased result.
Yes.
Yeah. My last question in the row is, as a litigator and a government officer, what alteration or addition would you suggest regarding Article 30?
As the need of the time, without striking Article 30, there should be a provision for keeping a check on the minority institutions by inducting the state and the central government representatives in it. One. Number two, from all sections of these societies, the number of students from the other not belonging to that same minority, linguistic or religious, the number of students taking admission to that colleges should be increased. Number three, this RTE should be made compulsory to them.
That is true. Yeah. Thank you so much, sir. That I think all the participant has got all the answer, whatever question they have asked. The session was very informative, sir, and you have given us such insight of the Article 30s, and your opinion are, that is clearly mentioned, and whenever your suggestion will be amended to that article, it will be a great, whatever, it will come out as a great thing if the amendment has been done. So it was very wonderful and very informative session, sir. We have currently 111 participants with us, which was there throughout the webinar. Now I request our Vice Chairman, sir, Shri Shantanu Kharia, sir, to propose word of thanks to Shri Pushyamitra ji.
Namaste, sir. Your session, it was very informative, and we had maximum number of teaching fraternity in our webinar present today. So it is good that they also know what is minority education institutes, and they also got an insight about how to create a minority institute, or how to run it. So basically, I thank you very much, sir, for enlightening us on this topic of Article 30. And I also thanks all the participants for coming and listening to this webinar and making it a grand success. Thanks a lot.
Once again, thank you so much, sir. I would like
Thank
to
you very much for
thank you
giving.
so much, sir. I do not have such words that you have given a very informative, very detailed, and very minute observation on Article 30. Thanks a lot, sir. I thank you, our chairman, sir, vice chairman, sir, our group director, sir, for providing such an opportunity and platform for all of us to get enlightened ourselves by such a great personalities. I request all the participants to please fill the feedback form after the session is over. And if you have not received the feedback form, then a mail will be floated for the same. So don't worry for that. You will get an e-certificate after 7 days of the date of the webinar. And once again, sir, thank you so much.
Thank you very much for
all
giving me this opportunity to share my views with your management staff and all those who have joined. Thank you very much.
Thank you so much, sir. Thank you once again. Thank you all the participants.